Burglary. We should now move on to the offense of burglary under English law. Now, previously we talked about robbery, and I want you to just stop to think for a moment. What do you think is the difference between robbery and burglary? Right? How different is it to rob a person or to burgle a person? Is it very different? And what would be the key difference? Now, we have seen that the difference between robbery and theft is actually robbery is basically theft with the use of force, right? Or with the threat of the use of force. Okay, so robbery is just an extension of theft, where the theft was committed with the use or the threat of the use of force. But what makes burglary different from robbery and theft? Let's look at the definition. The definition is found under Section 9 of the Theft Act 1968. Right? If you look at the definition under Section 9, you will see that the elements of burglary consist of the following. Right? The key part of the actus reus would be that there must be an entry into a building or part of a building as a trespasser. Right? So that's the key and the main part of the offense of burglary, where the accused entered into a building or entered into a part of a building as a trespasser. Now, burglary can be committed in two ways. The first way is under 9(1)(a), right, where the accused entered into a building or part of a building as a trespasser with the intention to commit one of the following offenses: to steal, to inflict grievous bodily harm, or to commit criminal damage. Right? So if a person enters into a building or part of a building as a trespasser with such intention, then he would have committed burglary. Now 9(1)(b) is where the accused entered into a building or part of a building as a trespasser, and after entering the building or part of a building, he or she commits theft or he or she inflicts grievous bodily harm on another person. All right. So 9(1)(a) is when he enters with the intention. 9(1)(b) doesn't matter what was the intention or whether the intention was there or not. Usually the intention was not there, but after entering into the building or part of the building, the accused commits theft or the accused inflicts grievous bodily harm on another person. Right. So then that's how a person can be said to have committed burglary under English law. So let's look at these elements one by one. We will first look at the element of entry, right? What does it mean to enter into a building or part of a building? When is a person considered to have entered into a building, right? Now, entry is a physical activity, so it's clearly an element of actus reus. So we got to see physically has the person actually entered into the building or part of a building. Now you look at this picture, right? Can the burglar or this person with the mask, with the striped shirt, right? Can he be said to have entered into this house or not? Right? Can he be said to have entered into this house or not? Right? Now, if the accused has actually gone inside the house, his whole body is inside the house, then it is quite clear that he's entered into the house. But the problem arises where only part of the person, right, enters into the building or part of or the part of a building, right? In this case, only one leg has entered into the building. His head seems to have entered into the house. His hands are on the window sills. Looks like he's going to cut his hands anyway. So is he being if he is stopped right now, right at this point of time, can he be said to have already entered into this house? What do you think? Let's look at the case law, right? And the first case that we're going to look at is the case of Crown against Collins, right? Crown against Collins is a case that is one of those cases that you will never forget for the rest of your life, right? It's interesting, it's funny, and as the judge himself said in this case, right, the facts of this case are so improbable as to be verging at times on farce, right? So even the judges themselves couldn't believe, right? Almost couldn't believe what actually took place in this case, right? One of the judges actually said that if someone were to write it up and give it to another person to read it, right? The other person will look at it and say that, come on, right? That is ridiculous. These kind of things will never happen, right? These kind of things will never happen. It is so improbable that it is verging at times on farce. Okay, I'm sure that this is one of the cases that many of you will quickly, would in the past I would say will run to the library, but now you'll probably go to LexisNexis and try to look for this case and to read the facts of this case. Okay, this was in 1973. This is a 1973 case, and the facts of this case took place in Colchester, right? But it's significant for me because I lived in Colchester for a period of time when I was doing my masters in the UK, right? So love that place. Colchester is in Essex, which is east of London, and Essex, if you're familiar, right? Being called an Essex boy or an Essex girl is something that is not flattering, right? That means it's not nice to be called an Essex girl or an Essex boy because this is what I found out when I was living in Essex anyway. Because it basically means that the person is not very bright. Okay, he's not very bright. And FYI, David Beckham is an Essex boy, literally, and okay, let's just keep it there, right? Literally, he's from Essex apparently. Okay, so it actually the victim in this case was an Essex girl, right? And the facts of this case took place during the summer months, right? During the summer months. Okay, so this girl, she lived with her family, and her room is at the top floor, right? Room is at the top floor, and she will sleep with her windows open. Okay, she'll sleep with her windows open during summertime. And a lot of us actually do that, right? For those of you who has experienced summer, you know how hot it is during summer. Okay. Now, Collins was the accused in this case was totally infatuated with her, right? You could say that he was probably stalking her, so he knew where she lived, and he would go to her house and look, and he knew where her bedroom was, so he would go to her house, and he will look up to the bedroom window, right, to her bedroom window. Now, one summer evening, Collins, who admitted was intoxicated at that time, and he said that he was actually feeling quite horny also. He made up his mind that he was going to go to this girl's house and he was going to have sex with her, whether she likes it or not, or whether she wants to or not. Okay, so basically, he has got the intention to commit rape. So he went to her house and he looked up to her window, and sure enough, the window was open, right? He managed to get hold of a ladder, okay, and put it onto the wall of the house, and okay, uh, this is where it gets interesting, right? And he climbed up the ladder. So he climbed up the ladder and he looked into the girl's bedroom, right, from her window, and he saw that she was asleep and that she wasn't wearing anything. It was a hot summer night, so she was sleeping in the nude, and he was very excited about it. So he climbed back down, and these are the facts of the case, right? He took off all his clothes except for his socks. Right? He took off all his clothes except for his socks. During the trial, when he was asked why he didn't take off his socks, he said that, or just in case if he was in the room with the girl and having sex with the girl, and the mother suddenly comes into the room, it would help him to be able to escape easier, right? And if you read the facts of if you read the judgment, the judges says that on that point we are not asked to give an opinion, and even if you're asked to give an opinion, we've got nothing to say about that. So anyway, he took off all his clothes except his socks. He climbed back up again, right? Now this time when he reached the window, the girl was awake. The girl was awake, right? She saw him at the window. Okay, she saw him at the window. It was a clear night. There was moon to light up the night, right? So she could clearly see, right, that this silhouette of this person standing at the window. And this is what she said in evidence. She could tell that he had blonde hair. I don't know how, right? Blonde hair in the silhouette. And she could tell that this it was a guy because she could see that in the silhouette that he had an erect penis. Okay, so she immediately thought that it was her boyfriend who was paying her a visit, right? As he has normally done so, right? He would sneak up to her room and they would have sex in her room. So she thought that it was her boyfriend again. Maybe this explains how come the ladder was there. Anyway, you can read the facts of the case to see whether there's another explanation for a ladder. So when she saw him there and assumed that it was a boyfriend, what she did was that she called him in, right? She beckoned him in. And the accused in this case was like, okay, fine, right? She wants me in. So she went inside and they had sex. Okay, they had sex. But halfway through the act, she realized that there was something which was not right. So she turned on the lights, and when she turned on the lights, she saw that it was not her boyfriend. She screamed, and Collins panicked, and he ran off the window and climbed down the window and went away. All right. Now, Collins was subsequently charged for burglary. Okay, why burglary, right? Now, we have seen that earlier on that under Section 9, person is said to have committed burglary if he enters with the intention to steal, to inflict GBH, or to commit criminal damage. Now, under the old law, in Section 9, before it was amended by the Sexual Offences Act 2003, one of the offences was also to commit rape. So so previously, Section 9 says that if he enters with the intention to steal, or with the intention to inflict grievous bodily harm, or with the intention to commit rape, or with the intention to commit criminal damage. So in this case, he was charged for burglary because he entered into the building, into the house, with the intention to commit rape, right? With the intention to commit rape. However, the question was at the end of the day, right? Did he enter as a trespasser? Right? Did he enter as a trespasser? Of course, we'll be looking at trespasser later on, right? Because you see, in this case, she actually called him in, right? She actually beckoned him to come in. So the judges in this case said that everything hinges on a very narrow point, as narrow as the windowsill itself. Because the question is that, did he cross over the windowsill before she invited him in, right? Before she invited him in. Because if he actually crossed over the windowsill before she invited him in, then arguably he would probably have committed burglary because he would have already entered into the building as a trespasser with the intention to commit rape. However, right, if she actually invited him in before he crossed the windowsill, that meant that when he entered into the building, then he would not have entered as a trespasser. Right? He would not have entered into a trespasser. So he would not have committed burglary, so to say. Now, in this case, there was a reasonable doubt, right? There was a reasonable doubt as to at what point did she actually invite him in, right? Whether was he still outside the windowsill or has he crossed over the window? I suppose she was half awake. It was dark in the room, right? She just saw a silhouette. It was very hard for her to tell whether he has actually entered or not, right? And entered into the window, entered through the window or not. Now, the court says that at the end of the day, when you talk about entry, it must have been an effective and substantial entry, right? It must have been an effective and substantial entry. Okay, but hold on there, right? We're going to look at the cases and see how the law has developed. Now, more than 10 years later, in the case of Crown against Brown, this was a case where the accused was found halfway into a building, right? Halfway into a building. So his legs were outside the building. His upper body was actually inside the building, right? And he was actually in a shop. He was actually going through some of the things to see what he could steal and he was caught in that situation. Now, the court in that case said that at the end of the day, even though it was a partial entry, right, it was sufficient to be considered an entry under Section 9. Because at the end of the day, all that is needed is to show that the entry was an effective entry, right? It was an effective entry. So Brown seems to disagree with Collins, right? Where Collins said that there must be an effective and substantial entry, right? Brown held that all is needed is just for there to be an effective entry, right? So it doesn't have to be substantial. It doesn't have to be majority of his body has got to be in the building or even his whole body, right? Much less majority of his body. In this case, only half of his body was in, right? Is it considered to be substantial? The court said it doesn't matter as long as part of his body is already in the building and it was effective enough for him to do what he wanted to do. In this case, he was committing theft, right? So there's no requirement for the entry to be substantial anymore. But hang on there, right? Another 10 years later or so, right? In the case of Ryan, this was a case where the accused was actually caught halfway in, halfway out, and he was stuck, right? He was trying to squeeze into the building and he was stuck and he was found in that position and he was arrested. Now, he was charged for burglary also. And in the case of Ryan, he was found guilty. So it seems that Ryan has done away with the requirement that the entry must be effective because it was not an effective entry. He was stuck there. So unlike the case of Brown, where he was halfway in and it was effective enough for him to look through the things there to take whatever he wanted to take. But in the case of Ryan, it seems that there is no need for there to be a requirement that the entry was effective also. So at the end of the day, right, there don't seem to be a requirement that the entry must be effective, nor must it be a substantial entry. At the end of the day, as long as there is entry into a building. So it could be just as simple as a person sticking his hand into the building and taking something out. I always remember my friend told me that that's what happened to him, right? He would leave his things on his study table, which was next to the window in his house, and things would go missing. So he presumed that somebody probably came outside his house, stuck his hand in to his table and took his things away. Now that, although only the hand entered into the building, that would be sufficient to satisfy the requirements for the offense of burglary. Okay, so when it comes to entry, it's a physical activity and there is no requirement that it must be effective nor substantial as long as there is some entry into the building. Okay, now moving on, let's jump building first and we talk about trespasser, right? Usually it's together. You must enter as a trespasser, right? So in the case of Collins, the court held that the defendant must know that he was entering as a trespasser or he was reckless as to whether he was trespassing or not. Because in the case of Collins, he would probably he probably argued that, well, I'm not a trespasser because she actually invited me in. So I thought that she wanted me to come in. All right. So his argument would probably be able to satisfy the requirement that he did not know that he was trespassing. But is there a question of whether was he reckless that as to trespassing? Was he really sure? Maybe there was a risk that she made a mistake, right? And she would not be inviting him. Why would she actually invite him into his house? So most probably it would be a mistaken identity. Okay, so the accused must know or be reckless as to trespass, right? So basically, it's very simple, right? So to be a trespasser, you basically enter without permission. It's pretty straightforward, right? Uh, in Jones and Smith, in the case of Jones and Smith, the definition seems to be extended a bit further. Okay, because in the case of Jones and Smith, the two defendants here, what they did was that they went into Smith's father's house. Right, Smith was basically living in his own place, and he, together with Jones, went into uh, his father's house, and they stole a couple of TV sets from there. right? They stole a couple of TV sets from there. Uh, the defense basically submitted to the court that they were not trespassers because they had permission to go to Smith's father's house. He actually allowed them into the house. However, the court said that yes, even though you were allowed into the house, however, you were not allowed into the house to steal the television sets or to commit theft. Okay, so you had the license to enter, you were allowed. However, it is considered to be trespass if you exceeded the terms of license to enter, right? If you exceeded the terms of license to enter. So if you go to a certain place where it's open to public, but then you smoke or you bring a durian there, right? The owner of the place have a right to actually refuse entry to you or do not allow you in or ask you to leave, okay? Because you have exceeded the terms of license to enter. You can only enter if you do not smoke, if you do not bring in a durian, or if you do not bring pets in. So similarly, in the case of Jones and Smith, their permission to enter was obviously limited to the fact that they are not entering to commit theft. So because they did, they have exceeded the license to enter, and therefore they would have they are considered to be trespassers. Right. So moving on to building and part of a building. Right. So being entering as a trespasser into a building or part of a building. Another one of the photos that I took when I was in Amsterdam years ago. Right, this is a boathouse. Very interesting, nice colors. And I thought it was interesting that they had grass growing on the roof of the house. Right? I wonder what kind of grass that was. So is this considered to be a building? What do you think? Yes? Probably. How about this? A caravan. You consider a caravan to be a building? Well, let's look at case law, right? Case law uh, held that for something to be a building, it must be a structure of considerable size and permanence, right? So two requirements, size and permanence, right? It must be a considerable size and it must be there, well, there must be some degree of permanence there. Okay, so if that's the case, then the caravan will probably not satisfy the definition of a building because it is not there permanently. It's meant to be on the move and on the go. So similarly, things like a tent also, right? Not there permanently, just there temporarily. Temporarily. If it's a small tent also, then it may not satisfy the requirement of it being of a considerable size. Now, this definition is found in the case of B&S and Leafly, right? B&S and Leafly. In this case, theft was committed at the farmhouse in a storage container like this, something like that, right? Something like that. Let's see. It was 25 feet long and 7 feet wide, right? 25 feet long and 7 feet wide. So that is of a considerable size, and this container has not been moved for 2 years. So there is some degree of permanence there, and therefore, when the accused in this case broke into this container to steal things from it, he was found guilty of committing burglary because he entered into a building, right? This was considered to be a building. So something of considerable size and of permanence. Now, what about part of a building? What does part of a building mean, right? Now, the case of Walkington. The case of Walkington was the facts took place in a uh, shopping mall, right? In a shopping area, a shopping mall, shopping uh, complex, something like Debenhams. I just put this up Debenhams because it's British anyway, but it's not. I don't think it's Debenhams. Now, what happened in this case was that what the accused did was that he actually entered into an area, something like this, right behind the counter. So the counter was obviously meant only for staff, and he entered into this area behind the counter, and he stole something from there. Right, he stole something from there. Now he was charged for burglary because he was considered to have entered into part of a building. This this place here, right, which is cordoned off, which is closed up to the members of the public and only meant for members of the staff, was considered to be part of a building, right? So although he was not a trespasser into the shopping mall, he was considered to have been a trespasser into that part of a building. So, for example, if you go to a building and then it says that for only members of staff, okay, or in Malaysia it says only for hands and legs, right, for kaki tangan only. And if you're not kaki tangan, then by entering it, you are considered to be trespassing into that area. Okay, just like how the staff rooms on a campus are like, right? There is a sign which clearly says that only for authorized people only, right? For students who are authorized, but yet, almost on a weekly basis, you will find students trespassing into the staff room. It does not help, right, that other lecturers allow them in and in fact encourage them to come in, right? Encourage them to come in, and usually the law lecturers like myself, we are the bad guys, and we always go up to the students and tell them, "What are you doing inside here? Don't you know that you are not allowed to be in the staff room?" And the reason is always the same, right? I said, "Oh, I'm looking for this lecturer." I said that go and use the phone. That's what the phone is there for outside. The extension is there. Extension number is there. Go and call the lecturer and tell them that you are here. And you'll be surprised, right? How many times the answer will be, "Oh, I called already and there was no answer." Then I'll look at them and say that then maybe your lecturer is not there. Of course, I can be a bit more sarcastic and say that, well, maybe your lecturer is there, right? Maybe your lecturer is there, but your lecturer just don't want to take your call. So get the message and just leave, okay? All right. So yeah, I can be quite mean sometimes, but then it's very frustrating because we've got personal items in the staff room, and then we've got private and confidential materials in the staff room. Things like exam papers, things like exam scripts lying around. And it's so dangerous for students to be just walking in and out, right, of the cubicles where we leave these things on our table on the assumption that it is safe to do that because students are not allowed into the staff room. So those people are clearly trespassing, right? And in the case of Walkington, it is considered to be trespassing because it was that part of a building, right? And the staff room is considered to be part of the building where they are not allowed in. And if they enter in, then it would be trespassing, right? It could be trespassing. Section 9, subsection 4 goes on to talk about the situation where this building can also be an inhabited vehicle or vessel, right? It can also be an inhabited vehicle or vessel. So, going back to what we said earlier on, if you look at the definition of BNS and Leafly, it seems that the caravan may not be considered to be a building, but Section 9.4 actually allows it, right? Section 9.4 actually allows it because it says that a building, right, not just must it be as defined as in the case, but Parliament has said that it also includes inhabited vehicles or vessels. Okay, so we've got the main actors reus satisfied already. There was entry as a trespasser into a building or part of a building. Then we now look and see at the mens rea or at the two ways of how the offense can be committed. It can be committed by 9.1a or 9.1b. And 9.1a provides that it will be burglary if it has entered with an intention to commit theft, to inflict GBH, or to cause criminal damage, right? So the key thing about 9.1a is that there was an intention when he entered into that building. So there must be an ulterior offense, right? The intention must be possessed before or at the time of entry. And that brings us to the problem, right? What if it is a conditional intention? Now, we talked about this when we talk about theft, conditional intention. And we see that generally for theft, conditional intention is not good enough, right? It's not good enough because there must be an identifiable property. Conditional intention means that if the person says that I will only steal something which is worth stealing. Okay, similarly, now in this case for burglary, what if there's a conditional intention? He says that I enter into this building with the intention to steal only, right? With the intention to steal only if there's something worth stealing. And there are two cases which decided upon this. In first case, the case of Hussein, right? The case of Hussein involved a van, the Avengers van. I don't know. Okay, but the accused came across a van, and when he looked into the van, he saw that there was a bag in the van. So he broke into the van with the intention to see whether was there anything in the bag that was worth stealing or not. Right? The court held that there was no theft involved in this case because it was a conditional intention. You see, for theft, there must be the element of property that was identified. So there must have been appropriation of property belonging to another, right? Appropriation of property belonging to another. But you compare that with the case of Aegis reference number 1 and 2 of 79. Now we talked about this case. This case is directly on point, right? Where the AG referred the matter to the court and asked for the court's opinion. What happens if a person enters into the house with a conditional intention to steal? That he enters to steal only if there's something worth stealing in the house, right? Enter the house to steal something only if it is worth stealing, right? The court says that when it comes to the offense of burglary, it doesn't matter, right? It doesn't matter. You don't need to have an identifiable property because the key thing is that whether did he have the intention to commit theft or not, right? Did he have the intention to commit theft or not? That's under 9(1)(a). Here you don't need to show that theft is committed, right? You do not need to show that theft is committed. All you need to show is that there was an intention to commit theft. You do not need to show that GBH was inflicted. All you need to show that there was an intention to inflict GBH. And you don't need to show that criminal damage was caused, right? As long as you can show that there was just an intention to cause criminal damage. Okay? So that's under 9(1)(a). And 9(1)(b) is where the prosecution cannot show that the accused had the intention to commit the offense when entering into the building or part of a building, but the prosecution can show that after entering into the building or part of the building, the accused commits theft or the accused inflicts grievous bodily harm on another person. If that's the case, then it would be burglary. Okay, so burglary can be committed either by 9(1)(a), when he entered into the building or part of a building as a trespasser with the intention to commit one of those offenses, or under 9(1)(b), where he entered into a building or part of a building as a trespasser, and after entering into the building, he commits theft or inflicts grievous bodily harm on another person. So two methods on how burglary can be committed under the Theft Act 1968, right? 9(1)(a) or 9(1)(b). So the key thing about 9(1)(b) is that the offense must be committed. 9(1)(a), you do not need to show that the offense was committed. So take a look at this little comic here, right? This person standing next to the couple in the bed and says, "Good evening, sir. Can I interest you in one of our latest security devices?" Now the question is that do you think that this person can be charged and found guilty for burglary or not? So we go through the elements, right? Burglary is actually very easy and it's quite fun. So we just go through the elements. Has he entered into the building? Yes, clearly his whole body is in the building. Substantial entry into the building, although substantial is not the requirement, but in this case, there was clearly substantial entry. And he was in a building. This was a building which is a dwelling place because you can see the couple there are sleeping in their bed. So he's entered into a building, right? Was he a trespasser? It will look like it because you look at the expression on the man's face, on the man in the bed, right? Look at his expression. He seems to be shocked at this person. So then we are satisfied the fact that he has entered into a building as a trespasser. But can he come under 9(1)(a) or 9(1)(b)? 9(1)(a), do you think he entered with the intention to steal, or with the intention to inflict GBH, or with the intention to commit criminal damage? No, it doesn't seem like it. His intention was actually to try to sell some security devices, some burglar alarms to these people, right? So he will not fall under 91A. Then we see what about 91B? Now that he's already entered into the building as a trespasser, can he be said to have committed 91B, which is that he has stolen something or that he has inflicted GBH on anybody? And again, you will see that he has not stolen anything and neither has he inflicted GBH on anybody. So therefore, he cannot be charged for burglary, right? Even though he entered into the building as a trespasser. However, right, he does not satisfy the requirements under 91A, having the necessary intention, or 91B, having committed theft or infliction of GBH on anybody after entering into the building. Okay, so that is basically burglary. Pretty straightforward, pretty interesting or pretty fun. Just to think further, right, 91A, do you think that it is fair? Just having the intention to commit this offense is sufficient for you to be charged for burglary, right? Do you think that that is fair? Is it sufficient actus reus or not? Because here he seems to be found to be charged for burglary mainly because he had the intention only. But you have to bear in mind that he has also committed a substantial part of the actus reus, which is entering into a building or part of a building as a trespasser, right? Entering into the building as a trespasser. So as long as he has has done that and he has the necessary intention to commit these offences, both actus reus and mens rea has been satisfied. Now, very quickly, going on to Section 10 of the Theft Act, right? A person is guilty of aggravated burglary if he commits any burglary and at the time with him has any firearm, imitation firearm, any weapon of offense, or any explosive. So if he commits burglary and at the time when he commits the burglary, he has with him some gun or imitation firearm or any weapon of offense or any explosive, then it can be aggravated burglary under Section 10 of the Theft Act. Right? Now, this is a very serious offense. It carries life sentence. Okay, finally, the punishment, right? The sentencing, which you do not need to know for purposes of examination, but just for completion, for sake of completion, right? Theft under Section 7 of the Theft Act 1968, the punishment for theft is 7 years maximum. So Section 7, 7 years. For robbery, it is life imprisonment because it is the act of theft plus the use of force. So the maximum sentence would be life imprisonment. And for burglary, you see that burglary is also quite serious, right? If it's a dwelling place, then it can be up to 14 years. It can be up to 14 years. Burglary is viewed as quite serious because I don't know whether you have actually had the misfortune of experiencing your house being burgled or not, right? My family did when, thankfully for me, when I was away, right? When I was away overseas, unfortunately, my family had their house broken into, right? I cannot imagine how it must have been for them, right? This is your house. This is a place where you are comfortable with, right? And to think that somebody was actually there, going through your things, touching your things, right? And yeah, the sense of security that the house brings is gone. I remember a friend once told me that his uncle, after having his house burgled into, was never the same. He was always very paranoid and very afraid that people will break into his house again, right? So much so that if he would bring his family out for dinner, halfway through the meal, apparently he would actually excuse himself. He would go into his car and he would actually drive back home just to make sure that everything was secure and that nobody has broken into his house. So that's burglary. Okay, right. So that brings us to the end of burglary. We will be going on next to look at what the penal code provides for an offense which is similar as this. You'll see that there's no burglary under the penal code, but you will see later on what it is called.